All right, I'll begin. Good morning. My name is Fernanda Lazaro, and I'm the Customer Service Rep at LAS, Local Authority Services at AMO. And I'd like to welcome you to today's webinar, Occupational Health and Safety Due Diligence Challenges for Directors and Officers of Municipalities. Before we begin, we recognize that our work at AMO, LAS, and the work of our members takes place on traditional Indigenous territories across Ontario. And we recognize and respect the history, languages, and cultures of the First Nations, Métis, and Inuit of all Indigenous peoples whose presence continues to enrich our communities. I am pleased to be joined by Sobi Raghunathan and Adi Yelepantula from 4S Consulting Services. AMO partnered with 4S in 2019 to offer members health and safety training and consulting services, including a comprehensive online management system at exclusive pricing. Many municipalities have seen the benefits of the 4S offerings and continue to use their training and their compliance system to this day. This morning, Sobi and Adi will speak to key occupational health and safety challenges faced by directors and officers of municipalities, providing occupational health and safety due diligence, requirements under Section 32 of the Occupational Health and Safety Act for municipal staff, roles and responsibilities of directors and officers, and sustainable solutions for managing your occupational health and safety program effectively. So with that, I'll turn things over to Adi and to get us started. Thanks, Adi.
Thank you very much, Fernanda. And I'd like to start off actually by thanking Nicholas and yourself for arranging this amazing webinar and giving us the opportunity to get one-on-one, at least virtually, with, I keep saying the word virtually, but I'm waiting for the day when we actually do these physical ones. So at least you're getting virtually one-on-one with your membership, and to share some of the thought building processes and strategies and the ideas and some compliance experience that we have with your membership. So thank you so much for arranging all of this, and thank you, AMO, and welcome to the webinar on OHS due diligence challenges for directors and officers of municipalities. So let's quickly move to the agenda. What do we have today on the agenda? Why are we here today? And you have an ISO 45001 lead auditor and an IHSA core auditor to explain why we are here today, and an OHS compliance experienced OHS compliance consultant. So then we'll quickly jump into the OHS challenges like Fernanda mentioned, faced by directors and officers, and give a quick sneak peek on the mandatory OHS compliance requirements, regardless of which industry you're in Ontario, and the relevance of Section 32 of the Occupational Health and Safety Act for directors and officers, and then roles and responsibilities of directors and officers, and some more case studies, which Sobi will be going through and explaining the whole relevance of why we are here today and what are the key takeaways. So before I pass it on to our speaker, I'd like to give a quick intro on who she is, and her name is Sobi Raghunathan. Sobi is an IHSA Associate External Core Auditor and ISO Lead Auditor. She is also the Vice President Strategic Partnerships for 4S Consulting Services, Inc. Sobi has been supporting diverse Canadian businesses of different sizes and implementing and maintaining sustainable solutions in the OHS programs. Sobi is part of the League of Champions of the Ontario General Contractors Association, and she constantly contributes as a safety leader to various industry associations such as the AMO, and we proudly partner with many associations to help people such as you. So without any further delay, in fact, Sobi also sits on the board of governors for the Ryerson University. So without any further delay, let me hand it over to Sobi Raghunathan, our speaker for today, to start explaining and set the context on why we are here today. So we picked a case, so you won't see the names of the municipalities here, but this is the whole idea is to set the context. And Sobi, all over to you.
Thank you so much, Adi and Fernanda. I do want to start off by thanking AMO for bringing a large number of audience today for the due diligence seminar. This is one of my favorite topics because this is the foundational topic for building a very strong health and safety management system for any type of organization, whether it's a township, municipality, to privately owned businesses, publicly owned businesses, every under the Occupational Health and Safety Act, they do not differentiate what type of a business it is, but everybody have responsibility for workplace health and safety. That being said, I do want to start off this today's session with getting you to understand some of the context behind workplace health and safety. The best way to understand the context behind workplace health and safety is to actually start looking at some of the accidents and incidents that has happened, and then look at the details of what went wrong and who was held responsible for what went wrong. So we picked one of the cases. I'm sure you must have seen this in the news forecast in the last couple of months. CEOs has been getting charged. This particular one kind of relates to that particular case. Where a hospital worker there was two of the hospital workers were injured, and as a result, the township was fined along with the CEO. The CEO's fines came at a later date, but this one particularly focuses on what went wrong and for what reason. So I do want to allow each and every one of you a couple of minutes to quickly read particular case, and then we will talk about how do you go about establishing due diligence. Please take the time to quickly read through the points in this particular case. So the major highlight here is section 25, subsection 2H of the Occupational Health and Safety Act. This is a common reason why many individuals and organizations get charged under. The last point, it says, Ontario municipality failed as an employer to take reasonable care in developing and or establishing a procedure for the safe entry to and or egress from the common work area, in this particular case, when a person is presenting with escalated behavior, according to the section 25(2)H of the Act. The 25(2)H of the Act talks about, have you done everything reasonable under the circumstances to protect the employee? We'll be closing off this session with going into the details of section 25, which is the employer's responsibility, and why 25(2)H is a common occurrence in many of the cases. So that being said, who are officers and directors in a municipality? Unlike any organization, municipalities are complex because you have CAOs who are appointed, who are looking after the day-to-day operations of the municipalities, but you also have the elected members as the city councillors who oversee and has the best interest of the details and functionalities of what happens in the municipality. So how are all these people covered under the Occupational Health and Safety Act? So these are some of the details that we are going to be focusing in. Some of the common OHS challenges faced by directors and officers is the common one that I normally see in many municipalities is not understanding the OHS responsibilities. Unless you have a very robust health and safety management system in place, majority of the people do have an opportunity to improve their knowledge and understanding the OHS responsibilities, because they are broad and they are very specific in certain aspects of the responsibilities. The second is assuming that you have a very good health and safety program in place. One of the common thing I do see and hear in conversations with many different organizations, whether it's being municipalities to, manufacturing or construction outfits. In my 22 years of experience, the common thing that I do normally hear is, well, you know what? We have a pretty decent program in place because we haven't had much accidents or incidents in the last so many years. Is that good enough to assume that you have a good health and safety program in place? Because just because you haven't had any accidents or injuries, it does not mean that you have a good health and safety program in place. It means that your luck has been pretty good in the last so many years, but you cannot keep going with that. So you do need to really take a deep dive inside to see, do you have a robust health and safety program in place? So do not assume anything. The third most important thing is auditing your health and safety program. Many organizations have not even thought about auditing their health and safety program. Just like any other program, like your financial program, where you do get, financial auditors, third-party auditors to come in and audit your program to give you an unbiased report of where you are with your financial management. You do need to audit your health and safety program. Again, the key word is unbiased opinion that professionals who understand the full spectrum of how a safety management should be and how it's being managed at your organization. So auditing is a very key component, and it needs to be done in a consistent manner. Many places that I have been to, they do the ones that who do have done the audit, they would do it maybe 5 years ago and then they haven't done anything, and they're waiting for another 5 years to schedule it, and many reasons are given due to budget constraints. Well, we haven't got approval. There's many reasons for it, but not consistently auditing is a big factor and a challenge. So please do pay attention to that. And balancing priorities, which is the most common thing that all of us here, we wear many different hats, and health and safety sometimes do go to the back burner because it is not a main priority of ours that has been identified. This is one of the most concerning things, because health and safety should be part of your culture. Health and safety should be your day-to-day activity. It should not be seen as something that you do need to do an extra step for it. So balancing priorities, again, is a common challenge, but moving forward, health and safety should be a top priority. Looking at the mandatory OHS compliance requirement, I'm sure many of you do know and understand this or have heard about it, but just to refresh, if you regularly employ 25 or more employees on a regular basis, which includes part-time as well. I know some of the municipalities are very small, but if you have 5 or more employees who are regularly employed, and it could be part-time, but the key word is regularly employed, then you do need to make sure you have a written health and safety program in place. And as part of your written health and safety program, you would start by identifying hazards and exposures based on what they would be performing as regular duties, and then writing policies and procedures to mitigate those risks, providing the necessary training, and ensuring that they are following the written health and safety program and holding people accountable. So a program includes hazard assessment, policies, procedures, training, how we are going to hold them accountable. All this is part of it. If you have 20 or more employees regularly employed, then you need to establish a joint health and safety committee. Joint health and safety committee must consist of minimum 2 workers, one being 2 people who are certified, have to be certified. And in order to be certified, you have to take training from a ministry approved certified training provider. And the one out of the 2, one of them have to be a management member, a supervisor, or a managerial type of a member. The other one is non-managerial worker or the employee who has no management or supervisory responsibility. If you have more than 5 employees, you do need to have a site's safety person identified as a safety rep. The minute that you have 20 or more, then you need to have a joint health and safety committee established with minimum of 2 people, and those 2 people have to be trained in joint health and safety committee, which is right now a 5-day training program. At 4S, we do have the government approval to provide the training as a blended learning. So you could take it partially as an e-learning for 16.5 hours and then come for part 2 as 2 days of hazard-specific training, helping them understand the various different hazards and how to control those hazards as part 2. So part 1 and part 2 combined, depending on the methodology that you take for the training. If it's virtual, it's a 4-day training. If it's in class, you're looking at approximately 5 days of training, 3 days for part 1 and 2 days for part 2, and it have to be provided by ministry approved training providers. There are 4 methods in Ontario that every employee, regardless of the job functions that they perform, every employee in Ontario have to have 4 mandatory training. WMS 2015, health and safety awareness. If they are a non-managerial member, they have to take health and safety awareness for workers. And if they are a supervisor or a manager or a CAO, they have to take health and safety awareness for a supervisor. This goes through the basic duties and responsibility under the Occupational Health and Safety Act and regulations. So it allows them to understand their rights and responsibilities and understanding of the Occupational Health and Safety Act. It is a mandatory training. Every employee in Ontario must take this training. Workplace violence and harassment, it's another training. A lot of people have a lot of misunderstanding about it. You need to ensure your employees have some level of training. You know, thanks to the virtual world and the online world, pretty much all of these training from an awareness perspective can be given as e-learning. This is one of the main reasons for our partnership with AMO is we do have quite a bit of e-learning modules, and this is the easiest way for you to show compliance and make sure all your employees are trained with the WMS 2015, workplace violence and harassment, health and safety awareness, and the 4th training, which is not related to health and safety, but every Ontarians must take this training to get a basic understanding, is AODA. So these are 4 mandatory training that is required in Ontario, despite whatever job functions they may have. So please ensure your organization, your municipality is complying to these 3 basic requirements. These are the basic compliance to start with. If you have 5 or more employees, make sure you have a written health and safety program in place. In order to have a written program, you do need to start with hazard assessment. If you have 20 or more people regularly employed, ensure that you have a well-established joint health and safety committee, and the committee is trained and it is functional. It is meeting bare minimum every quarter, and inspection of your facilities are taking place minimum monthly for at least portions of your municipality, and the mandatory trainings are given for all employees at any given time. If you have new hires starting, make sure that you have a process in place to ensure that all these people are trained in a timely manner.
Sorry, so I thought you were done, because there are a couple of questions which are pertinent. Once you're done, let me know. To the slide, there are a couple of questions that you may want to answer right away.
Perfect. So let's take up the questions that they have.
Okay. Mark Coleman asks a question here. It says, do you employ 20 or more employees in total or in one location?
So Mark, to answer your question, it is overall 20 employees, not in one location. So you may have your recreation, you may have your library, you may have your water treatment, but overall, if you have 20 employees, then you do need a joint health and safety committee. And my recommendation for municipalities is, when you are creating a joint health and safety committee, it is advisable for you to at least have one person from each of the different facilities join in, and you do need to get approval from the ministry to run a joint committee for overall municipality, representing various different locations from each of the various different units within the municipality. But if you do want to establish a joint health and safety committee for one of your locations, for example, your recreation has more than 20 employees, then for due diligence purposes, do establish a joint health and safety committee for that location. Anything that has a high risk, establish a committee if you have more than 20 people, and then join with the overall municipality's joint health and safety committee. I hope I answered that question for you, Mark.
Thank you, Sobi. Then James asks, James Tuck, he asks, the 4 mandatory courses, are they yearly or what's the schedule for renewal?
So this is where the Occupational Health and Safety Act gets a little bit gray. In the WMS regulation, it is very clearly defined. WMS must be reviewed with their employees on a yearly basis. That is very clear cut. And review can be form of an e-learning module. It can be you bring a group of people together and then go over the WMS program and talk about some of the major hazardous products that you carry at your facilities. That could be part of a review for WMS. But in terms of employee awareness, training, health and safety awareness, workplace violence and harassment, and AODA, they do not specify a particular time or expiry date to it. For workplace violence and harassment, it is my best advice to all the employers is to provide this training on an ongoing basis, just like WMS. Do the over and above the minimum compliance. Even though the Act does not say that you need to do it on a yearly basis, review it with their, provide the training on a yearly basis. So you keep reminding your staff about the do's and don'ts, what is allowed, what is not allowed, because workplace violence and harassment is such a very fine line where the misinterpretation or some people's behavior can be seen as a violent or a harassment gesture. So in order for employees to start understanding what is allowed and not allowed, I would highly recommend provide more training and more consistent training on a regular basis.
Thank you, Sobi. Melissa asks another question. Melissa wants to know, do you consider volunteer fire? It's very interesting, actually, the question. Do you consider a volunteer firefighter as an employee for your employee count of 20 or more? What do you think?
Again, it is one of those gray areas that it is not very clearly defined in the Occupational Health and Safety Act. But if they are a regular volunteer, do include them. My best advice to all of you, always do beyond what the minimum standard says. The Act and the regulations are your bare minimum standards. For you to establish due diligence, please go over and beyond. So if you have volunteer firefighters, consider them in your regular count.
Thank you so much, Sobi, for those questions. We took them right now because they're pertinent to the slide. So let's move over. All yours.
Thank you so much. What is reasonable? I mean, this question always gets asked. When we talk about doing everything reasonable under the given circumstances to protect your workers, this is all about due diligence. How do you go about establishing due diligence and what do you need to prove? So how do you know what is reasonable? So let's look at some of the major components of the health and safety program. And I will give you some tips and tools on how to go about establishing reasonable ground for that. So in the Occupational Health and Safety Act, Section 32 of the Act further defines the responsibility for directors and officers. Every director and every officer of a corporation shall take all reasonable care to ensure that the corporation complies with this act and the regulation. So the Occupational Health and Safety Act and the regulations, and orders and requirements of inspectors and directors. So anytime when the Ministry of Labor inspector comes in and give you orders or any directions, you do need to comply with it. And any orders given from the minister, you do need to comply with that as well. So the blanket statement is every directors and officers. So, you know, there are certain provisions where you can say as councillors and mayors, you may not be covered under Section 25, but Section 32 of the Act kind of puts a blanket cover on that by saying that you do need to ensure that you are showing compliance for the Occupational Health and Safety Act.
Sobi, sorry, there's a question here. You want to take it now or later? It's a question from Chris Wells. It was pertaining to the previous slide. It just came in. It says, where do you find requirements for JHSC for one location in the Act? That's number one. The other part is the MOL has advised us that we do not qualify to have a single JHSC for our multiple locations and that each work site needs to be treated separately. They have gone so far as to tell us that we are not allowed to call our group with one of each work site member a JHSC. What's your take on that, Sobi?
Because, you know, it all depends on the size and nature of your municipality. If you have a large municipality where you have many workers working within each of the locations, as I said, you know, your recreation to your water treatment, to your transportation, to your healthcare, then you do need to treat them as separate sites. And separate sites do need to have their joint health and safety committee, and again, follow the rule of establishing a fully functional joint health and safety committee. That means you do need to have minimum 2 people. If you have 50 or more employees regularly employed for this particular location, then you need to have a minimum of 4 people part of the committee. And rule of thumb, you cannot have a more managerial members. So it have to be either 50-50 or it could be slightly more on the worker side, but you do need to meet the minimum numbers. So you do need to have a minimum of 4 people and minimum of 2 people have to be certified members, again, 1 from each of the worker and managerial side. These are minimum requirements. My advice to all of our clients and people who attend my seminar is invest the time and resources to give the knowledge so that you will have a knowledgeable team that's going to be supporting you in sustaining your health and safety program. If you do not invest the time and resources to train them, how can you get the additional support that's needed to maintain and sustain your health and safety program? So please do not restrict yourself to the minimum number for Joint Health and Safety Committee training. Do train a little bit more than the minimum number. So you should be looking at having everybody certified. So when they go to the basic training, the Part 1 Joint Health and Safety Committee training gives the foundation to the Occupational Health and Safety Act and the regulations, and how a program should be implemented and maintained. What are the duties and rights of the inspectors? What are the functionalities and responsibilities of the Joint Health and Safety Committee members, as well as safety reps, and what they need to do to maintain the program, identifying hazards, understanding the hierarchy of controls, controlling the hazards, importance of doing inspections, investigations, and how to manage the overall health and safety program is covered in the Joint Health and Safety Committee Part 1. So I would highly encourage pretty much majority of you to encourage all your members in the Joint Health and Safety Committee to have this foundational training. Hope that answers your question, Chris.
It ain't over, Sobi. There's a follow-up question, sorry, by Melissa for the previous question, the volunteer question. Melissa wants to know that back to the volunteer firefighters, I understand that the recommendation is to have them to do the mandatory trainings. However, should they be included in the count of the Joint Health and Safety Committee? Interesting question, Sobi, for you. Yeah.
I would highly recommend, again, when we talk about due diligence, it's not bare minimum standard. It is you being able to show that you have done everything reasonable under the circumstances. So please do not read the act and say this is the minimum requirement. Always do over and beyond. I would definitely encourage you to include them in the count. You are not going to go wrong by including them in the count, because they are there on a regular basis supporting the day-to-day functions of doing various different things, and their hazards and exposures needs to be factored in. The committee is there to oversee some of that. So I would highly recommend you to include them in the count as well. So the relevance of the Section 32 of the Occupational Health and Safety Act for directors and officers, the direct relevance is each and every directors and officers are they can be personally charged when there is a workplace accident or an incident. The first case that we actually projected, they first charged the township, and then later on, the beginning of this year, they have charged the CEO of the hospital for the negligence. So they can personally charge the directing minds for such situations, especially critical injuries and fatalities. Again, these are personal fines, and they can be also sentenced for jail term. The biggest change that happened to the Canadian Occupational Health and Safety Act is the introduction of the Bill C-45, which happened in 2004. It amended the Canadian Criminal Code to include workplace negligence under the criminal law. So if anybody shows that or was able to not, if they were not able to prove due diligence, they can be personally charged under the criminal negligence. So these are common things that do happen on a regular basis, but it is the lack of understanding and awareness towards workplace health and safety responsibilities. People don't understand that they can be escalated and charged personally. So Again, jail term faced by people are becoming a common thing. Many cases where supervisors and some of the business owners have been charged under criminal negligence and jail term for that as well. It all depends on the severity of the case as well as the level of due diligence. So if they are doing everything reasonable under the circumstances, and if that can be proved, then you don't have to sit there and worry about what's going to happen to me. But in an event, if you cannot prove that you are doing everything reasonable under the circumstances, then you are open for possible fines if there was a serious occurrence that was to take place in your workplace. Indirect relevance is your municipality's reputation can be tarnished. Again, it's when you have a critical accident, and if the municipality or the organization is being charged or the individual is being charged, it becomes a public knowledge. If you go to Ministry of Labor's website under Occupational Health and Safety and click on in-court cases, you could see all the organizations that are being charged. In fact, the case studies that we have pulled are from there. They do update on a day-to-day basis and has all the details of, who it happened to, what happened, and how much they're being charged and for what reason. Again, being a municipality, the faith of your community might be impacted. If you had a fatality or a critical injury in your municipality, see how the community is going to be impacted by that. Again, staff morale goes down, and it has many impactful situations that creates with low morale, not being able to get the full support from the various different parties. This particular slide talks about OHS non-compliance has tangible and intangible implications. So the tangible ones, which is very evident, the courts and the government fines, surcharges, administrative costs, legal cost, investigation times. I mean, one of the things that people do not realize is the amount of time and energy it takes to investigate and then address the concerns that comes from those investigations after a serious occurrence has a lot of cost that's involved in it. You may have to shut down certain areas of the operation depending on what has happened, and which is going to have other implications in terms of service being provided. A lot of time on legal cost and legal resources going back and forth, requesting for more documentations and all kind of other things. A training cost, again, there may be additional training that would be required to fulfill some of the requirements that comes out as recommendations. So the cost definitely goes up. And I'm sure all of you do know that WSIB made a huge change to the rate groups. Now, pretty much it's performance-based. So the more number of accidents and injuries you have and lost time days, your insurance cost is going to go up. I know for municipalities, it is a different, depending on, which tier that you fall under, you may not have the direct impact from it, but you do need to pay attention to number of incidents and lost days caused from those incidents. And the intangible ones are definitely the reputation to the directing minds, as well as the brand repair from, pretty much the name of the municipality gets branded as well. So when we look at the roles and responsibilities of directors and officers, especially CAOs and the managers and various different supervisors within the municipalities, this is the general duties that applies to all of you. Under Section 25 of the Act, you do need to provide reasonable precaution. So this is a summary, but towards the end, I will go through each of the line item directly from the Act for Section 25, because That's one of the most important one. I want each and every CAOs to understand you are legally responsible, and you do need to make sure that you're doing everything reasonable under the circumstances to protect all your employees. Ensuring maintenance of the program, providing appropriate information about hazards, about all the various different things that takes place within your municipality. Cooperate with the Joint Health and Safety Committee, support that's needed for the committee, and ensure you are meeting the regulatory compliance, at least the minimum compliance that's required. And it is your responsibility to maintain the program. In many places that I have visited, not just municipalities, many workplaces, they may have a health and safety program. If you go to, if you were to take a sample of 100 different places, I would say a good 80% of them will have some health and safety program implemented. In most cases, they have downloaded a health and safety manual, or they have paid for a consultant to give them a standard manual for them. But you cannot confirm that as maintaining a health and safety program. And the program have to be relevant for your organization. A blanket health and safety manual, it's not going to cover all the policies, procedures, hazards that are involved in your organization. So maintaining your program, as time changes, you may introduce a new process or a new equipment for one of your locations. Again, as part of maintaining your program, you do need to go back and revisit your hazard assessments, reevaluate the program, come up with any policies or safe operating instructions for that particular task. So that's all goes back to maintaining the program. Making Health and Safety Act available for all your employees. Provide any explanatory information pertaining to health and safety, and make the OHS reports available to Joint Health and Safety Committee. So if you were to do hygiene testing, you do need to make sure there is full disclosure to the Joint Health and Safety Committee, that they could actually have copies of the report, review it, and give their recommendations and feedback on that. Under the Supervisors Response, under Section 27, supervisors have to be competent persons. Again, under Section 25, you need to ensure you're appointing competent people as supervisors, and competent supervisors need to make sure that advice on hazards and potential exposures are given to their employees. So they do need to alert them of potential hazards and give them advice on potential exposures and how to go about safeguarding them. And need to ensure that regulatory compliance, basic compliance is being met. The supervisors need to ensure proper PPE that's identified for the various different tasks are being followed, and provide written instructions as required to the workers. Again, do everything reasonable under the circumstances to protect the employees. Disciplinary actions for non-conformities are taken care of, and you do need to maintain records. Due diligence, in a simple term, is doing everything reasonable under the circumstances and documenting that you are doing all this. You cannot go in front of the judges and say, well, I did this, but I don't have any records to prove that I have taken whatever is reasonable. That is not going to stand in front of the judges. You do need to have documented processes, programs in place to prove that you have done everything that you need to do. So due diligence, can you prove it? How do you go about proving it? So the next few slides, we are going to discuss how do we go about proving that we have done everything reasonable under the circumstances. One of the foundational pieces to Occupational Health and Safety Act is hazard assessment. I always tell the analogy that the hazard assessment is like a foundation. If you don't do the hazard assessment, but you have gone and written your policies and procedures, then what you have done is you have gone and put up a structure without making sure the foundation is solid. So it's on a shaky ground. hazard assessment, there's I could take 10 municipalities, and I would tell you that at least 8 of them needs some sort of a support in doing a detailed hazard assessment. Hazard assessment, it is quite a required task where you do need to understand how to go about identifying hazards, how you do need to have a good understanding of hierarchy of controls so that you could go about rating the hazards and then coming up with control measures. Again, hazard assessment is the foundation of a good health and safety management system. So if you feel that you don't have proper hazard assessments done, hazard assessment must be done for each and every different task that is performed within the municipalities. So if you look at, again, I'm going to pick recreation to libraries, to daycares, to healthcare centers, long-term care centers, to water treatment, to waste collection. You need to have separate hazard assessments, and detailed hazard assessment must be done for the various different functionalities and the tasks performed within those functionalities. Again, once the hazard assessments are done, hazard assessment should be able to give you, if it's done properly, again, my word of caution is revisit your hazard assessment. If you haven't done it properly, get professional help to get it done once and for all, the right way, the detailed way. It is an investment. It is a time required task. So maybe get the experts to give you a hand in developing the hazard assessment. It is an investment I would highly, highly encourage each and every one of you to consider as part of your budget proposals. Because once hazard assessments are done properly, it is going to give you the proper roadmap for the policies and procedures that are needed. Your safe work instructions for any high-risk task, any personal protective equipment that's required for some of the specific tasks that you would perform, and additional training that you would need. So the various different types of training that you would need, you do need to make sure that it is captured. So when we do hazard assessment, we always make sure there's a training matrix, there's a PPE matrix, there's a policy and procedure matrix that comes out from the hazard assessment. Then it makes your life easy to maintain the program as you move forward. So if there's a particular process that you went and made changes to it and added, let's say, equipment to do the process much better, then you go into that section and update that particular hazard assessment, and then make sure that all the necessary changes to your policies, procedures, if there's additional requirement for PPE or additional training, reflects all the various different changes. And always make sure that your procedures meet or exceed the standard. Do not always allow for the minimum requirement. I know when it comes to Joint Health and Safety Committee as an example, of locations I have visited in the past do follow the bare minimum of quarterly meetings. I always recommend, can you do a little bit more than that? Whatever recommendations I'm making today for due diligence presentation, it's not exactly what says in the act. My recommendations are always doing a little bit more than what the act asks you to do. So can you meet at least every other month? If you have had more accidents and incidents in the past, my recommendation is meet on a monthly basis till you bring that under control. Because when you defer the meetings for longer time period, then it's not front and center to you. The actions that you need to take may be delayed and prolonged. Whereas if you were to meet on a regular set frequency that is a shorter duration on a monthly basis or every other month, then you are moving ahead in taking actions within a shorter time period. And do you have proof of staff reviewing your procedure? This is one of the common things I see as an opportunity. Again, If you haven't audited your health and safety program by a professional, a third party with the unbiased view, some of these things may not be revealed to you in the past. You may have policies and procedures, but how do you ensure your staff have been given the opportunity to read and understand what is in their policies and procedures? You know, when we talk about simplifying health and safety program and making sure it's sustainable, thanks to this day and age, there are many software solutions available. Again, with the AMO partnership, that was one of the main reasons that they partnered with Forest. Forest also have a ForSafeCom system where all your policies and procedures can be assigned to based on the hazard assessment, based on the functionality. You could go in and assign the various different policies and procedures to the various different staff, and they have to read and acknowledge it. When they read and acknowledge it, you will get a report. You could run reports that says the various different locations who have read it and acknowledged it, who have yet to do that, so you could follow up with them. Because it is your responsibility to make sure the staff reads and acknowledges the various different policies and procedures that are applicable for them. And you do need to have some sort of records to show that this has happened. So paper records are needed or electronic records are needed to prove due diligence. Workplace inspection and investigation. Inspections are proactive measures, investigations are reactive measures, but both of them are a must for you to maintain your health and safety program. Monthly workplace inspection is needed. In the Act, it says parts of your workplace have to be inspected on a monthly basis. And at least the entire organization must be inspected at least once a year. If you have such a large municipality, it may be impractical for you to do monthly inspection of all the locations every time. So you may want to divide it up and come up with a schedule to do inspections where parts of the organizations are constantly being inspected. The whole purpose of inspection is to identify any potential hazards that exist in the organization before it becomes an accident or an incident. Identifying hazards, understanding the hierarchy of controls, you do recommend controls or corrective actions. How are you going to fix that particular hazard? Timeline, again, based on the hazard and the hierarchy of controls, you do define a timeline. If it has the potential to cause serious injury, it needs to be fixed immediately. If it's a minor hazard, then you have time to fix it, but you do identify and you do need to have some sort of a documentation to track the action that's required and the corrective action that you are going to be taking. Once a corrective action is taken, you do need to put a completion date on it to say it has been completed and resolved. These are, again, opportunities that I always see when we do gap analysis or safety compliance audits. You know, they are doing the inspections, they are maintaining the inspection reports, but corrective actions, tracking the corrective actions and completion of corrective action is definitely an opportunity I commonly see when we do gap analysis or compliance reviews, safety audits. Again, these opportunities tells you that there are little gaps that you do need to bridge. Again, I'm going to recommend in this day and age to have a management system that can track inspections that's being done, who did it, then it actually alerts the various different people to take actions. Once they take the corrective actions, it updates with the timestamp to say that it has been completed. With incidents, again, have a defined, for inspections, have a defined policy and procedure indicating the frequency of the inspections, who's going to do it, when it's going to be done, standardized forms to perform the inspections, and then to follow up on the corrective actions and completions of it. It should be in a procedure, and same goes for accident incident investigation. You need to have a procedure in place, and in your procedure, you do need to clearly define what type of accidents and incidents need to be investigated, who should be investigating it, and what actions do you need to take. Again, accident investigation is a reactive process, but you can learn a lot from what went wrong and make sure that you take preventive actions to prevent a similar type of reoccurrence in the future. So root cause analysis and prevention and recommendations for corrective actions and communications are key to accident investigation. And that should be very clearly stated in your occupational health and safety procedures. And as part of your gap analysis or audits, these are details that get revealed. Are you doing all this? If not, what are some opportunities? All that gets revealed in the audits or the gap analysis. Ensure your supervisors and Joint Health and Safety Committee members are trained in doing proper workplace inspections and accident investigation. You know, if you don't understand what you need to do and how to go about handling these situations, then you're not adding value to the program. Moving on to the third major component is employee training and orientation. Make sure you have an effective documentation or effective process to deliver training. We spoke about mandatory training, and this day and age, maybe e-learning is the easy and simplest way to deliver the training and show compliance, rather than having an individual sit there and repeat themselves for 2-3 hours doing the training. Always when you're looking for solutions for how it's going to make it easy for you to manage, at the same time, would you be able to grab the documentation and data from whatever process that you're implementing? Again, when you have new hires, you do need to do orientation. The orientation must include any of their specific exposures and hazards for the various different tasks that they do. So you would have a standard orientation for the organization, and then you do need to do a specific orientation based on the job specifics and provide training on the specific hazards as well. Do train and retrain staff on job specific hazards. You know, it is very common thing that we see training is provided. In most cases, we would see training records that was done 3 years ago or 5 years ago, but refresher training was not done on a regular basis. If you do have equipment such as forklifts, scissor lift, Zambonis, you do need to provide refresher training on these equipment. You do need to also, certain arenas where there is construction going on, you do need to make sure fall protection training is given and go a little over and beyond, rather than just doing a standard fall awareness training, do the working at heights training, which talks about specifically on how to tie off, and it is a regulated training. It can only be provided by ministry approved training providers. So again, this is going over and beyond the basic requirements. And make sure that your staff reviews and acknowledges safe work procedures and instructions, and have some process in place to track the reviews, track the training records. This is why I always recommend making it simplified and easy. This day and age, you should be able to find a health and safety management online system, which is going to help you track the training delivery when refreshers are coming up, alerting you on all that, along with review of policies, procedures, acknowledgements can be tracked. So make sure to prove due diligence, you do need to have some record of, if you don't have any systems in place like online system, then you do need to sustain and maintain paper records of all this. Is your management trained on safety responsibility? Your middle management and your senior management must dedicate the time to take additional training on health and safety. This is nowhere written in the Occupational Health and Safety Act, but if they don't understand what is their responsibility, how do they go about, controlling hazards and understanding the exposures, how are they going to support in maintaining and sustaining your health and safety program? I would highly, highly encourage and recommend each and every one of you on a yearly basis, or at least every other year, bring your middle management team together and do some sort of a health and safety training. It could be basics of supervision, it could be due diligence, it could be a specific training for your municipality on the various different topics. There are many ways you could facilitate training. At Forest, we have done various different support for the different municipalities where our trainers goes in and dedicate a week, once a week over the course of 2 or 3 weeks. You bring the team together. It is a team building exercise, as well as getting them to understand their obligation and responsibility, how they are going to be supporting you in sustaining the health and safety program. So do invest the time and money to train your middle management. OHS due diligence summary, again, just to summarize some of the things that I have been talking about in the previous slides, is due diligence is an ongoing process. Do not say, I got it done, it is there, I have documents. You need to make sure it's live. You can keep your program alive. You need to keep your program alive to stay in compliance. So that's why we always say, be in compliance, stay in compliance, keep your program alive. Do your safety compliance review. This could be a gap analysis or audit, compliance review. It all boils down to the same thing. Do a compliance review of your health and safety program every year, or minimum every 18 months. Some of the municipalities are so large, you won't be able to cover everything at once. Come up with a plan and do it stage by stage. So, again, start with your high risk as your top priorities, get the compliance review done for those, and then visit the following year and make sure you do the other locations. Continuous improvement plan definitely helps you to show that the management, the directors and officers have a plan that they have defined for health and safety, and they are following that plan. Ensure all your employees takes the mandatory training and hazard-specific training. Hazard-specific training is defined after doing a thorough hazard assessment, and it should give you a training matrix to say what kind of additional training is needed beyond the mandatory training. Get experts to review your program. Again, this is the audit, the safety compliance review, unbiased third party giving you a report which really adds value to the due diligence. Some of the places that we have visited, it's the people who are managing the program auditing themselves. Bias always gets in the way, so be aware of that, because you want to be unbiased, you want to have a path forward, and you want to come up with your continuous improvement plan, focusing on actions that you need to take. And it should be done by people who have a very good understanding for the entire safety management system. People may serve the role to manage health and safety, but they may not have the overall understanding. So that's why we always say, get the experts to review the program. Track and maintain the OHS program effectively. Implementing your program isn't enough. You need to make sure it's sustainable. That's why I was recommending, there are many options out there. Look for a OHS management online system where it can actually help you deliver the online training, track the training, track your inspections. Your inspections report can be online. You can review it to see if corrective actions have been taken or addressed. You can also look for accident investigations, do your trend analysis, making sure you are taking actions based on the trends that you are seeing to control potential hazards and exposures. This is all going towards managing the health and safety program. So that's kind of some of the details I want to give in terms of due diligence and documentation. At this point, before moving on to the case study, maybe we could take some of the and then move on to the case study.
Thank you, Sobi. I have a question. I have three questions here, Sobi. One is from, pardon me if I've pronounced your first name wrong. It's Misha Suen. Are mayor and councillor members considered directors and officers under Section 32?
Mayors and councillors can be defined under Section 32. We are looking for more of a concrete direction from the ministry, but right now, the direction that we have is they are deemed directors and officers.
Thank you so much, Sobi. So Lana Tanner has a question. She's asking for communicating and training on policies and procedures. Any recommendations for reaching groups without computer access more efficiently, like the paper-based model? What are your recommendations for those municipalities following a paper-based model, basically? So
if you are following a paper-based model, make sure whatever training that you're providing, you have a training a sign-in sheet. So you actually put the date, time, give a description. As an auditor, I always say, give a description of the training, attach the training description, and then have signatures of the people who have attended, which departments or job titles, date, time, with their name and signature should be there as a proof. The same goes for policy procedure acknowledgement. You do need to give them a copy of the policies and procedures, and you do need to retain signatures saying that they have read and acknowledged the policies and procedures.
Thank you, Sobi. So there is another question from Lana. So Lana also asks, can you please speak about, and it's one of your favorite questions as well, can you please speak about modeling your program after core versus ISO? The ideal person answering the question, Lana, for you.
Great question, Lana. I'm glad you asked this question, because if you really look at it, and we are going to be having another seminar maybe in February or March for the municipalities. We are going to be doing a seminar on bringing the CPO and WSIB to talk about the WSIB excellence program and part to becoming the safest employers in Ontario, which applies for all of you as well. I know the rebates may not be there depending on the schedule that you are in for WSIB, but you can become the safest employer. So the only way to become a safest employer in Ontario, there's three routes. One is being part of a safety excellence program. And one of the things that I do want to propose is, if there's enough people interested, we can create a safety excellence program for AMO. Or we have already created a solution where we work on 5 topics at a time with the client to make sure that they are following. So we start from year 1 all the way to year 5, following the safety excellence model, to make sure the entire health and safety program meets the standards. Right now, there are 2 standards the Ministry of Labor MLTSD is looking at. It have to be either core 2020 standard or ISO 45001 standard. Core 2020 and ISO 45001 standards are great standards to follow. In fact, we pretty much, when we come in to do a gap analysis or an audit, we normally follow, we would use the template of a Core 2020 for a program that is a little bit more well established, because the Core 2020 is very prescriptive. It defines what you're looking at and how we are going to be scoring on it. Whereas the ISO 45001 standard is open for interpretation, but it defines the program for you. So in order to become a safest employer in Ontario, you do need to have course certificate based on, become a core certified company based on Core 2020 standard, or become ISO 45001 certified. If not, you start topics in, following the excellence model, which is 5 topics at a time. And over the course of 5 years, you should have the entire topics covered. And then you could actually submit the documents to become a safest employer in Ontario. I hope I answered that question for you, Lana. The next 2 case studies, I do want each and every one of you to take the next couple of minutes to read through what is being projected for the second case study, which is a worker stuck by exploding cap, and the municipality was fined $70,000 for it. This happened in 2018. So just take a quick read through of what happened and the background, and then the next case as well, so that we will have a quick discussion. When you're reading through this particular case, I'm sure many of you may be asking the question, this is such a common thing. This can happen to any of the municipalities. What do we need to do to prove due diligence? This particular incident was charged under, again, Section 25, subsection 2H of the Act. And the reason for that is the investigation that followed determined that the corporation of the Ontario municipality committed the offense of failing as an employer to take every precaution reasonable in the circumstances for the protection of worker, which in an offense under the Occupational Health and Safety Act. The employer specifically failed to take reasonable precaution of ensuring that the internal pressure of the drain pipeline was released before the mechanical joint end caps was removed and or loosened. Can this happen at any one of your locations where they may have similar type of situations? If the answer is yes, then start asking yourself, have I identified this as one of the potential hazards? And do I have, since it can be a high risk hazard, do I have any instructions for the workers to follow? And anybody who is being hired as a new employee for that particular area, are they being warned and made aware of the process that they need to follow? That is one of the quickest and easiest way for you to prove due diligence. And again, whatever you do, whether it's a paper format or the electronic format, make sure you have records that shows that it was reviewed, it was communicated, and training was provided if training or communication was done. And the last case, this is an interesting case, firefighters injured during training exercise, and Ontario municipality fined $55,000. It happened in June 2018. So I'm going to allow you to quickly read. Again, with this particular case, ask yourself the question, can a similar type of incident take place within your municipality? And if the answer is yes, then ask yourself, what have you done, or what as an organization have you done to mitigate this risk? And how can you go about proving due diligence for these type of situations? Again, in this particular case, they have charged under Section 25, subsection 2H of the Occupational Health and Safety Act states that the employer shall take every precaution reasonable in the circumstances for the protection of a worker. The Ontario municipality failed to take the reasonable precaution of providing a foot pump to inflate the keel of a Zodiac Grand Mark. It's an offense pursuant to the Section 66 of the Act. Again, you need to go back. This is why I said hazard assessments are crucial. Hazard assessments indicates, that's why hazard assessment must be done for the various different job functions or locations, and within those locations, the various different actions that take place and the equipment that are being used needs to be included in the hazard assessment. Once you do a hazard assessment, then you can also look at how to go about safely doing certain tasks within that. I do want to wrap up with kind of going over the section 25. Pretty much all organizations get charged under section 25(2)(h). Take every precaution reasonable in the circumstances for the protection of the worker is a common word that they use. And if you look at pretty much most of the in-court cases, that's the section that they do go after, because when they find out that you don't have a proper management system in place with paper trails to prove due diligence, they go after that particular section. So every employer in Ontario shall ensure that equipment, materials, and protective devices as prescribed are provided for workers. Equipment, materials, protective devices provided by the employer are maintained in good condition. The measures and procedures prescribed are carried out in the workplace. The equipment, material, protective devices provided by the employers are used as prescribed, and building structure, any part thereof, any part of a workplace where temporary or permanent is capable of supporting the load that may be applied, so on and so forth. And then they go on to subsection 2, without limiting the strict duty imposed by the subsection. An employer shall provide information, instruction, and supervision to a worker to protect the health and safety or safety of the worker. In a medical emergency, for the purpose of diagnosis or treatment, provide upon request information in the position, so on and so forth. When appointing a supervisor, appoint a competent person. Again, this is a key thing to pay attention to. You want to make sure whoever you are appointing as managers, supervisors are competent. They need to have the experience, the knowledge, and the training to do the job. Appoint a worker or a person in the authority over the worker with any hazards in the work, in handling, storage, use. So again, make sure that you are giving them instructions, you are giving them the necessary PPEs and holding them accountable to do the job. H, take every precaution reasonable in the circumstances for the protection of the worker. This is where they always go after and say, have you done everything reasonable? They come, let's say that hopefully you don't have to go through it, but it has happened in many different places. Critical accident takes place. Definition of a critical accident is you had a fracture to an ankle, a hand, you had a fall where it resulted, it could be a fall or any kind of a situation where it resulted in unconsciousness, severe loss of blood, amputation to multiple fingers. So any of these can be considered as a critical injury. A person falling off or tripping over something and fracturing the ankle is considered a critical injury. When a critical injury happens, Ministry of Labor needs to be notified, and when they come in, they would be looking at the entire program. One of the key takeaways and things I want you to remember, due diligence should be demonstrated by your actions before an event occurs, not after. So you having a well-defined health and safety program in place, hazards identified, you doing your compliance review, identify, opportunity for improvements, come up with your continuous improvement plan, making sure all hazards are identified, you have a well-established hazard assessment process in place, you have policies and procedures that are well-established, training is provided for all the mandatory as well as hazard specific, and keeping records and constantly maintaining the program, holding people accountable. If people are not following what is stated in the program and the policies and procedures, you have to have disciplinary action. You do need to document and make sure that it's consistently followed for everybody. If you're doing all these things, when Ministry of Labor comes in, they are not going to fine you. Accidents do happen. As an employer, if you have identified and addressed all the potential hazards and taken all the necessary precautions, reasonable under the circumstances, they are going to leave you alone. It is when you don't do all this, and when they see your program is weak, that is when they actually start looking for more and more details, and then they will come with the charges. So please do invest the resource and time to audit your program to first of all find out, are you meeting the legal compliance? Identify the effectiveness of your control measures. Are you having some tracking and analysis to measure all this? Do not ignore near misses or any kind of potential incidents. Look for trends that's happening within your organization. Then based on those trends, come up with recommendations for continuous improvements. Implement and identify improvements and training for everyone. Training is ongoing. Invest in training. Training your new staff, training your middle management, and refresher trainings must be given as well. Not looking for measure, again, looking for leading indicators and lagging indicators and proactive control measures. All this helps in sustaining your program. Assuming that OHS program is good as there have been no incidents is the wrong attitude. Make sure you do audit your program and come up with your continuous improvement plan to tackle it. Our recommendations for a strong OHS management system, put it in your budget to do a gap analysis. Again, unbiased gap analysis. Based on the findings of the gap analysis, come up with your continuous improvement plan. Then based on your continuous improvement plan, communicate that to your workplace. Then take action, hold people accountable for taking actions, review the effectiveness of the program. And the last point I will tell you is, especially for municipalities, the larger municipalities, your program is so large. There's many moving pieces. There's many locations or organizations within the municipalities. So identify maybe 5 objectives every year, following the model of the Safety Excellence Program. Come up with 5 objectives. This is something that we actually started doing with some of our clients, is with them on a month-to-month basis, where we have identified 5 objectives. Normally, when we start with it, we start with the gap analysis, and then always hazard assessment is your top priority. Revisit your hazard assessment and any of the high priority items. And each year, take on 5 additional. Keep on reviewing the programs and upgrading it and communicating to your staff. So that pretty much concludes the presentation what we had for the due diligence. We will take any other questions that comes up.
Thank you very much, Sobi. I do see a question from Eric Sanford. Eric wants to ask, can an individual director be charged under the Act? Is there any documented cases in where a director was charged and found guilty and fines imposed? I think one of the cases we showed was something to do with that. So maybe, Sobi, you could go ahead.
Thank you so much, Andy. Eric, good question. Definitely directors can be charged. There are many cases. Before they charge a director, they normally go through, have you done everything reasonable? If you have done everything reasonable, that's why due diligence is important. They are not coming after you. In the event you couldn't prove due diligence, then they will move up the ladder to see where things have failed. The first case that we showed to you with the hospital, the CEO of the organization was charged recently. First, they charged the municipality, then a couple of months ago, they charged the CEO for his negligence because he knew this existed and he didn't actually put this as a top priority to resolve the issues that were being brought to his attention. So directors can be charged, and there are many cases. If you go into in-court cases, you will see where they will list a manager or a supervisor or a director was charged for certain cases.
So we are good then in terms of the questions. So please let us know, Fernanda, if there are any further questions or do you have any closing comments that you'd like to make?
Toby, I want to add something. Just so I think it was Melissa that asked a question about the volunteer firefighters and everything. And it was interesting, Sobi, that one of the case studies that you brought up was, that. So I want to reflect on that. When you think of volunteer, it's just kind of like a part-time volunteer. You're not putting your full effort, a full time in all that part of it. So it's even more important. There's two things. One, it's volunteer. It's almost like a part-time. Second, it's the highest risk probably in the municipality as firefighters, right? You're dealing with a lot of high risks, exposures and things like that. So in my belief, I think it's critical for the firefighters to be involved as much as possible in regards to the health and safety program, and more so in regards to improving diligence of at least the mandatory trainings, and to be able to prove that you guys went and executed that. So I just want to add that comment because I saw that. I'm like, oh, I have to speak to that. So.
And Sobi, can I just add to that? You can correct me if I'm wrong. It's the section which defines the worker, who's a worker, was amended by the OHS Act, right, to include volunteers and those volunteering, as well as interns and students. So employers need to be cautious and cognizant of having students and interns working for them.
Thank you, Eddie, for that particular point. Yes, I was going to say that they did amend to ensure that, students and volunteers do fall under the workers category. So that's why I was saying the diligence and, a word of caution, whatever I am recommending here is over and beyond the bare minimum requirements in the Occupational Health and Safety Act. I know many cases people will come back and say, well, in the Occupational Health and Safety Act, it says this, but you are recommending this. But the reason why I'm recommending this is the Occupational Health and Safety Act tells you the bare minimum. When you follow the bare minimum standard, it is open for interpretation. So when you do over and beyond, then you're going into proving due diligence. And when you do more than what is required, if I'm an external auditor, I go in and audit other organizations to certify them for ISO or CORE. In those cases, I am looking for a safety management system. And what do I define by a safety management system? There is defined hazards for all the various different operations and exposures, defined policies and procedures. The policies, procedures, and hazard assessments are being reviewed on a set basis. So your policy statement, it states in the Occupational Health and Safety Act, needs to be reviewed on a yearly basis. It has to be signed and posted within 12 months. That's a common thing. But what about your policies and procedures? You do need to review your policies and procedures. As new hazards or modifications to your process gets identified, you need to go back and do the amendments and update your policies and procedures, re-communicate all that to your workers, and you do need to have some sort of a paper trail to show that you are doing all what you are saying you are doing. That's why in this day and age, I highly, highly recommend investing in an online safety management system, which will simplify the process for you to maintain all the ongoing mandatory training, hazard-specific training, policies and procedures, inspection records, investigation records, and then from the investigation records, you have trend analysis and dashboards that you could get for continuous improvement plan to keep on top of managing your health and safety program. When we go into an organization who's doing all this, it gives us the comfort that they have a structure in place. When the structure is not there, then we start looking for more and more details, more and more documentation to identify, because if the program is weak, then we will be asking more questions. We'll be interviewing more people. That's why the gap analysis, the safety compliance audits are crucial, because it's going to allow you to have a report that's given before something goes wrong, identifying opportunities that you need to address. If you don't identify the opportunities, how are you going to fix them? It's like you should. So again, working with many municipalities in the past years, go ask help, put it in your budget to get started with the safety compliance review. Once that's in place, then After that report, go again, ask for funding to put a safety management system in place or to revamp your health and the hazard assessments. Again, these are common things that we are seeing coming from municipalities and AMO members, is how we have been working in slicing and dicing these solutions. Start with something, then build on it. As long as you have continuous improvement plan, when you do a gap analysis, it clearly identifies actions you need to take. Then from there, you could come up with your continuous improvement plan, and then you could go in front of council and ask for budget to support that. So these are tips that I'm giving you from past experience of working with many different municipalities. As long as it's in your budget, then you could do it. And from our experience of supporting some of the municipalities in the past, that's why I said, pick 5 topics, starting from the basics, then start implementing those. And what we have done in the past with some of the municipalities is we had a strict monthly commitment. So we had our work cut out, and we were supporting them as an extended resource, helping them fulfill some of the issues that they needed to fulfill. So these are definitely opportunities and actions that you really, really need to focus.
So there's a question. Questions from Erica Rodin. The question is it possible for us to share a sample compliance audit with maybe Fernanda, for her to share it with?
So my answer to that is there are many different compliance audits, and it is a legal thing. I do not want to share anything, because if I'm sharing something, then we are putting, or Forrest gave this is what we followed. So there's legal issues with that too. But what I can tell you is, if you want to start off with something, there's 2 recommendations I'll make that are standards that you could follow. One is the old work well audit. But I would say go a little bit over and beyond and download the Code 2020 audit tool. And that audit tool will give you some structure for what you need to do to maintain your program. And I will also advise you, if you are the person who is managing your health and safety program, please do not audit yourself, because bias gets in the way, and you also feel certain things that you're implementing, but you may not make sure. There's definitely going to be opportunities in the way how you understand it and what you feel versus what should be there as an unbiased report. I hope that gives you some guidance on the audit tools.
Is there anything else you wanted to add before we wrap up?
I think I covered everything that I wanted to cover. Due diligence is an ongoing effort, so start and keep it going. Keep your program alive. So it's a living and breathing thing that you need to maintain and sustain. It's about evolving a safety culture. Safety should be a day-to-day process that's part of what they do. It cannot be seen as something that's standalone. So in many places, I definitely see opportunities for improvements, but get started.
John, do you have anything to say as a closing comment or something from your experience to share with the audience?
Well, just very quickly, I'm familiar with the municipality space, and I know that there's a lot of moving parts and so many different divisions within, different sizes of municipalities, obviously. But one thing I do know, there's a lot of seasonality, and there's a lot of part-times that are coming and going out. So the one things that I noticed from my experience, that some of the issues arise that some of the part-timers coming in, they didn't do a good rollout of orientation. So the one thing that Sobi did mention that I truly feel that you should put into your future budget is having an online management system to be able to communicate it. Because if you have a system that has all the policies, procedures, JSAs, like that's a job hazard analysis, and being able to deploy that a very effective, easy way. Everybody is really used to technology now. It doesn't matter what age you're at. And I think that is the best recommendation I can offer, is to really look at that for something in the future is going to help you manage your municipality, because at the end of the day, you're in your municipality office, and then you have all these different locations and all these different divisions that are all scattered. How do you control it? It's easier to be in control with a health and safety management system that's online, that you have oversight. You can be able to see what's going on without leaving your office. And it's best for you to prove due diligence and everything else, and how to improve having a system. And it's not tremendously crazy expensive, to be quite honest with you. And the best thing about a system, and I'm not speaking in bias, I'm speaking in 4RS, we have a tremendous, a great system that has all the online awareness courses, the LMS system that's in the same system. So it's easy to deploy, it's easy to track, it's easy to be able to communicate for orientation. So that is my full recommendation. In regards to the doing a job risk assessments and all these different things, yes, you're going to learn and be able, if you're going to do it on your own, there's a lot of things that you're going to have to learn behind the scene. You can bring in an expert to be able to help assist, but having a system is my opinion. I think that you should look at that first. So.
Thank you, John. I do agree with what John is recommending, because the mandatory training is a standard training, and hazard specific training with the system that John is talking about, it comes with over 85 online courses. So depending on the various different hazards, majority of the hazards are available as e-learning awareness-based training. So when you subscribe to the system, you're not paying per person per course. You're paying for the subscription of the system, which comes with the LMS for e-learning, and the mandatory courses get assigned as you go through the journey to identify hazards and upload the hazards in. Then hazard-specific trainings can be assigned as well. And training records for any of the training that you provide, whether it's, forklift, scissor lift, fall protection training, the hands-on training, the training records can be inputted into the system to sustain a training record. Policy procedures can be reviewed, assigned, and acknowledgement of those get tracked. Inspections for the various different locations. With municipalities, you have many different inspections within the various different locations. So you could set it up in such a way that the various different inspections for the different locations, the different checklists are enabled, so that they could do the inspections on their tablets or even simple as their phone. And when they submit it, it puts a timestamp and it shows which location when the inspection has happened. So from a due diligence standpoint, the directors and the CAOs or the directing minds can actually go into the system and run reports, or we could configure the dashboards where it alerts them based on the frequency that they have determined. Are the inspections happening? Are corrective actions happening? What is outstanding? Training completion based on percentage by location. So it's going to help you stay on top of managing the program. Not just only for training, but all the various different aspects of the program. So when you are looking for a system, it does not have to be for a system, even though AMO partnered with for us for some of these reasons. Evaluate the system to make sure that it manages the various different components of your health and safety inspection. It needs to monitor training, inspections, policy procedure review, job hazard analysis, accident investigations, and be able to give you dashboards and summary. If it can do all this, then you have a good system.
So Fernanda, one thing that I can offer, if there's interest, because you don't know what you don't know out there, right? And we're talking a lot of stuff that people are trying to even, to like, whoa, what does this look like? I'd be more than happy if there's interest in your municipalities to see a demonstration of our online management system. So at least this way they can kind of understand what we're talking about. I could do a demonstration, very participation, all that through it. And at least it gives them something as an option to consider in the future if this is something that they see would be a benefit for them. So that's something that we can collect some interest in the next, say, few weeks. I can do a demonstration in the new year, or between the December 15th to, how it's kind of slow around December 18th and 19th, people are going, okay, or in the new year, okay, if there's any interest.
Yeah, actually, when I send out the email, I will include Nick's contact, because Nick does run the program. He wasn't able to attend today, so that's why I'm here. But yeah, so you'll be able to just contact Nick, and then he'll be in touch with you to organize a demonstration. We actually did get a comment that a demonstration would actually be great. So at least, yeah.
Yeah, no, and yeah, no problem. And then, yeah, so we'll talk to Nick, and then we can make something happen in the new year or later at the end of the year, depending on everybody's availability.
Just one more thing I would add in regards to stress the importance of Joint Health and Safety Committee training. So if you can get more people trained, it's going to add value to help you maintain the program. So my recommendation for all of our clients and others who are signing in to listen to the seminars is always have more people trained and invest the time and resources in providing additional training to middle management as well. Because you could come up with all the programs, but if the middle management do not understand their requirements for maintaining and sustaining the program, then it's going to be dependent on you or one or two key individuals who are going to be constantly pushing to maintain the program. So you need their buy-in. To create the buy-in, I always recommend even Joint Health and Safety Committee, if you can bring municipalities together to do the training session. And as I told you, we are ministry approved. We do private training sessions. I would highly recommend doing private training sessions for the different municipalities, so you could have discussions about your particular program and the challenges that you face and how to overcome those. And also for middle management, supervisory training. So going over the 2 days of training, you could do it back to back 2 days, or once a week for 2 weeks, but do it as a private session. Do not do it as what you call public training session, just to put a tick mark, they got the training, because private sessions encourages you to have discussions about the challenges and opportunities about your specific program. And that is what you need.
Because each municipality may have a different area that they need to address, right?
Exactly. And thanks to COVID, virtual world is fully accepted. So, everybody can now go to the Zoom and stay tuned for the training sessions and participate in training rather than just having a person there to do the in-person training.
Thank you. Thank you, John. Thank you, Sobi. Thank you, Adi from 4S.
Thank you so much, Fernanda, for hosting the event, and thanks to Nicholas. And I hope this was good information for all of you. Do not hesitate to send us questions if you have any further questions. We are here to support you and work with you. So wish you all the very best. Stay safe and keep your program alive. Thank you so much. Have a safe and awesome day.
Thank you, everyone. Stay safe. Bye-bye.